Hi, Ken Ravago, lead property manager with the Ravago Group, and today I'm going to be talking about the top reasons that we've seen through the years landlords get sued by tenants over security deposit mistakes, and we've seen these end up in a fierce discussion, a lot of back and forth emails, or ultimately ended up with the landlord and tenant in court. So let's get right into it. So Nevada Revised Statute NRS 118A 242 talks about the landlord providing an itemized written accounting of the disposition of the security deposit and return any remaining portion of that security deposit to the tenant no later than 30 days after the termination of tenancy. As a practice here at the Ravago Group, we send that security deposit disposition within 30 days with proof of service, like certified mail. So we head over to the post office, or we use a program to make sure that there's a timestamp. If the tenant, or if the landlord fails to provide the tenant with an itemized accounting and refund by subsection 4, the tenant is liable to the tenant for damages. So you want to get that in on time. The first reason, or one of the top reasons, is taking too long to conduct that written accounting disposition of security deposit. You may think that 30 days is a good amount of time, but you are waiting on contractors, you are beholden to their schedule, you may be working a job, you may have family commitments. That 30 days will come faster than you know it. So it's very important that you stay in integrity with that 30-day window. Number 2 is confusing wear and tear versus damage. If you put around my office, we have some business photos, some personal photos, and some artwork. If I leave little pinhole or tack holes in the wall, is that considered wear and tear, or is that considered damage? We had a petite but strong judge years ago tell us, Mr. Ravago, if the hole in the wall is the size of my fist, again, just to put in perspective, she's about 5'2", 110 pounds soaking wet. If it's the size of my fist, then that's damage. If it's the size of a tack hole, then that's wear and tear. Nevada does not provide a lot of nuance, a lot of detail on what is wear and tear versus damage, but that example has resonated with me until today, that a tenant should be able to put up artwork, put up photos, etc., and leave little tack holes. And as a landlord, you will be responsible for patching those, touching those up, doing your make ready for the next tenant. It's highly unlikely that you'll win in a court of law deducting that type of expense against a tenant's security deposit. So be very cautious. Number 3, saying that a deposit is non-refundable. And I'll use pets as an example. On Zillow or HotPads or Facebook Marketplace, we've seen a lot of self-managing owners write $300 non-refundable pet deposit. Well, although I went to public school in the English language, that is an oxymoron. A deposit in its truest definition is something that's refundable unless there's a reason to deduct against it. So calling something a non-refundable deposit is a no-no. Number 4, forgetting to check the final utility bill. This is one that we've seen landlords get bit by in the past. So with our group, once a tenant moves out or prior to them moving out, we remind the landlord or owner to put the utilities in their name. By doing that, you're going to get a final bill, and you'll find out if the outgoing tenant has a past due balance. If you provide us that utility bill in time, particularly water, you provide that to us on time, then we'll be able to deduct that against the security deposit within our 30-day window. If you wait and you don't, then you won't be able to, and it's after 30 days, then you're going to be stuck with that water bill, or you're going to have to make collections attempt on that water bill, and good luck with that. Number 5, if you cannot prove it, you cannot bill it. A few days ago, I was supposed to meet my brother for lunch, Kim, one of our property managers, and he was a few minutes late. He mentioned he was at the property, at a move-out property, helping out the team, and he took around 300 to 400 pictures. That may seem a little excessive, but with a 1,600 square foot home, you want to, on average, you want to get every little nuance of that property to ensure that you didn't miss anything. With our group, we have a before and after. Well, if they moved in 2023 and they move out in 2028, we're able to cross-reference garage floors, walls, kitchen cabinets, etc. So the old adage goes, if you cannot prove it by pictures, you cannot bill it. Number 6, not considering the life expectancy of an item. I'll use carpet as an example. In the IRS depreciation schedule, carpet has a useful life of 7 years. Again, Nevada doesn't make a distinction of how long a useful life of an item is, but with carpet, if you have a tenant, if you buy a home and the carpet's 7 years old and the tenant lives in it for another 4 years, so you have a total of 11 years, and we have had instances where landlords would charge the tenant the full replacement cost of carpet, even though the carpet's 11 years old. That may give a judge or court of law a lot of heartburn, and you may have an uphill battle as a landlord charging that, because again, the carpet may be deemed past its useful life. So you need to consider that with if it's an appliance or it's a major item within the household, such as flooring, there's an expectancy or an expiration date of such items. I hope this video was useful. These are just, again, some of the top reasons. There may be other reasons where you may find yourself in a dispute against the other party. If you have any questions about security deposit transmittal, if you're going through a move out right now, please use this as a resource. We would be more than happy to talk property management with you. Ken Ravago, lead property manager of the Ravago Group. Until next time, we wish you the best of luck in your rental property endeavors.